Today we will be looking at the area of labour law and industrial disputes. As in all modern legal systems, labour law and workers' rights make up a fundamental part of the common law. Indeed, it is difficult to believe that less than a century ago, in many common law countries, the area of employment protection was an ideological battlefield, with trade union members jailed accused of communism and employees seeking to violently overthrow capitalism. Today, workers' rights have for the most part been secured, and the main issue in labour law is often not the extent of protection available, but rather ensuring that the law is applied as it should be. That said, the recent phenomenon of globalisation and delocalisation, combined with the recession, means that social tensions in Western economies are once again on the rise. First, we will look at the area of trade unionism. The growth of trade unionism has been one of the key elements in the evolution of relations between employers and employees. A trade union is an organisation made up of workers and exists to protect workers' rights. There are normally many different trade unions in a country, often organised along industry lines. Thus, there could be a transport workers' trade union, a coal miners' trade union, civil servants' trade unions, etc. Some tend to be more radical than others, but all share the same goal, the promotion of their members' rights. It should be recalled that trade unions primarily represent their members rather than workers in general. This goes a long way to explaining why workers in key industries, for example electricity workers, tend to be better paid than workers in non-key industries. Clearly, the threat of strike is more keenly felt in areas of economic sensitivity, and consequently, the trade unions representing these workers can secure better conditions for their members. To prevent some workers enjoying an effective power of blackmail over an economy, many countries have introduced minimum service requirements, whereby workers in sensitive industries must guarantee a minimum level of service, even when on strike. Other workers, such as police or soldiers, are often denied a right to strike. Such measures have been criticised by some as anti-democratic, which they probably are. However, it is probably equally anti-democratic for certain workers to hold an economy to ransom, and so the issue probably comes down to a choice between two evils. Now we will look at the different types of industrial action. Although the rate of strikes is relatively low in the Western world and common law countries, strikes are still the activity one probably most associates with trade unions. The right to strike is guaranteed in most, if not all, Western democracies, although, as we have seen, it is not absolute and is subject to control. Certain types of strikes are controversial, and some may even be considered illegal. For example, wildcat strikes. A wildcat strike is a form of industrial action that has not been voted on democratically by all the workers concerned. It is for this reason that such strikes are normally outlawed in common law countries. Wildcat strikes often begin by way of a walkout. A walkout is a situation where, in response to an incident, some or all of the workers in a business simply walk out of the business in protest. There are also sympathy strikes. Sympathy strikes are a secondary form of strike action, where the striking workers go on strike in sympathy with a strike in another business. The sympathy strikers will normally have no direct relationship with the workers or business on strike, or any tangible benefit or interest to protect. Instead, they go on strike to demonstrate their sympathy with other strikers and to add more force to their claims. Sympathy strikes are illegal in most Western democracies and common law countries, as they can mushroom into general strikes and potentially shut down a country's economy. However, there is nothing to stop workers boycotting the products of certain firms in sympathy with the workers of that firm. General strikes. A general strike describes a situation where a large proportion of workers frequently in a country or region, and from unrelated industries, all go on strike together. In the modern industrial world, such strikes are normally limited to one-day periods and are often used as a symbolic tool to communicate worker power to a government that may be seeking to introduce cuts or restrictions in social benefits. General strikes are, to a certain extent, a relic from the past, insofar as they are ideological in character, generally pitting workers against employers. This can be compared to the more modern form of strike, which involves workers in a particular business striking for an improvement in their working conditions. It is probably true to say that a general strike is more of a political gesture rather than an economic act. Indeed, general strikes can be self-defeating, as they tend to have an overall negative effect on the earning power of all the members of society, the striking workers included. And finally, lockouts. A business can also effectively strike by imposing a lockout on its workers, whereby they are prevented from accessing the business premises. This is often done as part of negotiations and as a way to force workers to accept a deal, as during this period, workers will not be receiving any pay. Now let's look at the issue of collective bargaining agreements. Today in common law countries, worker and employee interest is normally best represented and expressed in the context of the collective bargaining process. Under this process, trade union representatives and management enter into contractually binding agreements, which is effectively a negotiated settlement that neither side has a right to break. Collective bargaining agreements are often entered into on an industry-specific basis, and thus ensure stable industrial relations for a whole industry. We hope you enjoyed this introduction to labour law and the area of industrial disputes.